We're going to get started again and try to get back on schedule so that by the time we get to lunch, everything is moving like clockwork again. Our second panel is called Fostering a Culture of Disclosure in Criminal Justice. And I guess obviously since you've just sat in on the last panel, one of the key challenges to learning from error is if you don't know about the errors, you can't learn from them. And how do we foster a culture where people step up and disclose errors or near misses so that we can have a data set from which to learn? To moderate this panel, I'm pleased to introduce Penn Law Professor Stefanos Bibas. Professor Bibas directs Penn's Supreme Court Clinic, litigating a wide range of Supreme Court cases, including most recently a challenging copyright issue before the court involving the screenplay to the movie Raging Bull. Stefanos studies the powers and incentives that shape how prosecutors, defense counsel, defendants, and judges behave in the real world of guilty pleas. His 2004 paper, Plea Bargaining Outside the Shadow of Trial, explored the agency costs, structural forces, and psychological biases that cause plea bargaining to deviate from expected trial outcomes, and is required reading in many prosecutors' and public defenders' offices. He also studies the separation between criminal procedures' focus on efficiency and criminal law's interest in healing victims, defendants, and communities. His most recent book, The Machinery of Criminal Justice, explains how criminal justice should do more to encourage acceptance of responsibility, remorse, apology, and forgiveness, themes that I think we'll hear throughout the day and tomorrow. Stefanos?
Thank you, John, for all the wonderful work you've been doing to get the center off the ground. Thank you, Dean Fitz, the moving force behind the center. We will miss you, and thank you especially to Frank and Denise for the wonderful work and support without which none of this would have been possible. So I think the previous panel teed up the issues here very nicely, and I think that especially the comments of Professor Silby and Dr. Lee pointed out that we have to focus on whether we have a system at all and what it takes to make a system work. We talk about a criminal justice system, but I don't think what we have meets the very basic definition that the previous panel helped us to lay out. Number one, you got to define what's a success or a failure. And in terms of the wrong person being convicted, you can do that, but in terms of what are the practices you ought to be doing, we don't even have a very good definition of what are best practices in a lot of these areas. Number two, you've got to be able to measure failures, which we do a terrible job of. As Sylvie pointed out, we have windows onto individual failures. We know there's some uncounted number of false confessions, of flawed, faked forensics, etc., but we don't really know how many. And we also have to be able to measure successes. In the business world, you start by looking at what's successful. We don't have a very good way of measuring what's a successful prosecutor's office or successful public defender's office. And the third thing that I think Professor Silby talked about very eloquently is you've got to have a feedback loop. You've got to know what a success is, you've got to measure it, and you've got to be able to learn from your failures and successes. For it to be a system, it has to be capable of improvement and evolution. But what we have in criminal justice, it's called the criminal justice system, but it just kind of grew up. And it's never been planned, and it's never been evaluated systematically, and so the preconditions for improvement aren't there. And so the work of this panel is to focus on what we can learn from some other industries as well as pathologies in criminal justice about making the system better, about introducing a feedback loop so that we can tell how to improve it. So we might start with the debate that went in the first panel between there's certainly misconduct, there are certainly bad apples, there are certainly intentional and wrongful things that need to be punished. But there are also errors, which are very often inadvertent, unintentional, negligent. And we heard that to the extent that what we're dealing with are errors, a good apples, bad apples focus may not be the way to deal with it. And there's this tension between kind of punishing and remediating. And we want to do both for different kinds of misconduct versus errors. A quality control approach in other industries tends to focus on identifying and learning from error over time. Now, to the extent that these are good faith errors or mistakes, you have to bring them to the surface in order to be able to learn from them. But when you have them that they're undetected, unreported, sometimes even unknown, unanalyzed, because there's no process for figuring out that that central line could have been inserted differently, you're never going to improve. You don't have the basics for a system. How are we going to have accountability for the bad apples, the intentional misconduct, have victim compensation for the people who've been wronged and hurt, and there are real human faces here, but at the same time have a culture that allows people to bring things up, to talk about them in a way that promotes fixing them going forward. Criminal justice is way behind a number of other sectors, industries, etc. And so we've brought together 4 very different fields in this very distinguished panel here. Everything from aviation to fire safety to criminal justice to the medical field. You have very detailed descriptions in your program. My apologies, we don't have time. I'm not going to give the many accomplishments of our panelists. But let me introduce you briefly to each of the people we'll have speaking to us. First, we're going to have, we'll go in this order to my right. Ms. Linda Connell, who from a statistics background became the director of ASRS at NASA and runs the NASA Ames Research Center efforts there. After her, we're going to have Mr. Thomas Hicks, who is the Chief Programs Officer and Assistant Executive Director of the International Association of Fire Chiefs and a volunteer firefighter for 30 years. So you can help us out there. Hopefully no fires today. After that, my former student, Dr. Stephen Raper, who is here at the University of Pennsylvania, the Perelman School of Medicine and the Hospital of the University of Pennsylvania. He is an associate professor of surgery. He's also vice chair for quality and risk management, and he runs the morbidity and mortality conferences at the Hospital of the University of Pennsylvania. And he'll speak to us about that. And finally, Mr. Jeffrey Deskovic, who is, from his background as a wrongfully convicted defendant, an exoneree, went on to go and earn a master's in criminal justice and write a thesis on wrongful convictions, and to found the Jeffrey Deskovic Foundation for Justice, who will talk to us about the role of the media in sometimes exacerbating a rush to judgment and sometimes exposing injustices. So, without further ado, Linda Connell.
It is my absolute pleasure to be here. And I thank John for the invitation, Penn Law, and specifically the Quattrone Center. This is fantastic. The idea of this ability now to look at this topic in the criminal justice system is fantastic. My son, who's an attorney, is quite proud of his mother being here at Penn. I encouraged him every way forward on being an attorney. The first director of this system for aviation was an attorney in aviation law. So there is background in what is right and just in this system in aviation. But the concept and the model is being applied, as Chris Hart mentioned, to many other arenas in the U.S., including the railroad industry, and Amtrak is reporting to me, and I may hear about your problems. So we'll talk a little bit more about the specifics. Again, I am not from your community, so some of the things I say may not be directly translated. So keep in mind when you hear me say certain things, begin that translation process in your own world and try to find those pieces that might line up with that. This was a partnership from the beginning. It was between the regulator, the FAA, and NASA. NASA has a human factors division of which we're part of, so we're always looking at the human in the system. But it was simple, and I would encourage you to keep the kind of outward-facing parts of these changes you're making as simple. The complexity is behind the scenes when you've got the data and you're trying to analyze it and you're trying to make sense of it. But out front, this was to do 2 things. Identify and eliminate unsafe conditions to prevent accidents and assist the community. Very simple. It really has taken 3 entities to make this a success. NASA, as the, quote, kind of honest broker, third party. the regulator, and the community. In fact, this has to be equally balanced or it does not work. The system in the middle will be sacrificed if the power balance among these entities aren't balanced. The FAA provides all the money for this program and the limited immunity to people who report to the system. NASA provides basically that outside middle partner between the front line of the industry and the regulator. So we're in the middle. The community has to have power and be empowered in this paradigm because you're counting on those people to talk and to open up the conversation about what they're experiencing every day in the job we expect them to do and we train them to do. We have lots of governing documents, advisory circulars, there's air traffic control, there's actual codified protections for the data provided to this system in terms of FAA enforcement, and we have interagency agreements that go on between the two government agencies on a continuous basis. But again, it's simple. It's voluntary reporting. It's not a mandated reporting. It's open the door to hear about anything that someone would want to share with you. It is confidentiality protected, and NASA spends a good part of our purpose looking at how to de-identify information and get to the core issues. We're not concerned about the people. We're concerned about what they're telling us. We're concerned to protect them and third-party references. Again, we're not looking for blame. We're looking for understanding of what people are experiencing in the system. It is not non-punitive. The FAA does provide this limited immunity, and it basically says the FAA will not use this information in any of their kind of enforcement mandate, and we must have that. In a just culture, you have to have that regulator. But these reports cannot be used as any kind of evidence there. And the independence, Chris mentioned trust. This is where the trust is lying in this system, is that we sit aside of these other processes that go on in an everyday world. That's where the trust is. We can remain as unbiased as possible. We do not enter into opinion and judgment. We're gathering data and making the best quality assessment of that as we can. There is an advisory circular, so just to kind of say the standard of practice in the community is the violation must be inadvertent and not deliberate. It cannot involve a criminal offense in terms of them committing the criminal offense. It cannot be an accident. NTSB handles accidents in the United States. And it cannot disclose a lack of qualification. So if a pilot doesn't have a current rating, is not current in a medical exam, and all the requirements we expect, this system will not protect them. They cannot have prior enforcement actions for 5 years. And they must report within 10 days of the event. So there were many reasons about how these developed over time, but these pretty much have stood in the 38 years of this program. Again, the simple purposes. Get the information in from the frontline people, pilots, air traffic controllers, whether you're a commercial pilot or a single engine pilot like I am, you have the right to report to this system and can be protected for anything that may have happened. Identify the deficiencies in the system, not in the individuals, in the system, and alert the nation, and we alert actually the world about aviation issues. But don't stop there. Move the data into some kind of collection mode so that you have something to look at, can begin to look at what's going on. It's voluntary supplied, so it's not quite trending data, but we get 90,000 reports a year. The weight of the data begins to add some relevance to quantitative as well, and produce products back out into the community to reinforce the continuing. We feel strongly that when organizations want to learn more about events, the best approach is to simply ask those people who are involved. People are generally willing to share their knowledge if their identities remain protected, there's no disciplinary or legal consequence. If it's properly constructed, people will talk. Open that door and begin to hear the messages. I am amazed every day when the narratives come in from people out there experiencing things that neither you or I would want to experience. but are able to talk about it and tell us how they detected the problems, how they recovered from them, and that's why we are safe. These people are trained to tell us the story. And over time, in 38 years, aviation is very mature. But it's also a loop, and I think someone else had mentioned this earlier. It isn't a finite process. It's a continuous loop, a continuous improvement process. So you take the data in to reporting. We analyze all of this data by experts. These are pilots, air traffic controllers, maintenance people who have been there, done that. They have the credibility at the front end of the system to look at this important information and read between the lines, to understand the perspective of where it sits. I do not have data handlers handling these kinds of subjective, qualitative reporting. These are experts. Once they've captured it in a reliable way, now I can start to get into higher level analysis into data. But again, push it back out with product. Get to that 6 o'clock position on this circle, the learning from the system. And the person that developed this ASRS was a medical doctor, Dr. Charles Billings. He was one of many. John Lauber from the NTSB, many people were involved in this creation. It's stood the test of time. So the ASRS is a learning type of reporting system. It generates hypotheses from the data that's provided to us that get tested in other ways, in other parts of the system. It detects these issues, sometimes weak signals. It could be one report. I don't wait for 50. If one report is describing something that is very hazardous, we move on that one report. Sometimes we don't have enough details, but we call the people back. We begin to explore that with them. We get those details. Or, if it's a hot topic, I'll get 60 in 1 week. It's also a quality assurance check. When aviation makes a change, I watch and I see whether that change has taken effect and whether these reports continue to flow. But always keep in mind these reports, when you open the door, there's a bit of luck involved. Did that person report? Did everyone report? No. You know that you don't have 100%. But all I need is one to expose a hazardous situation. But what it is not is the reporting system is not a whistleblowing reporting system. It is not an accountability enforcement system. It's not an adversarial system. And it's not big data as well. If you look at big data systems, they're much bigger than 90,000 reports. But what's inside this, of the 90,000 I get, are those pearls, those gems, those events that by the grace of God go I. And if anyone can get to that point, you begin to move and make changes. This model is being applied around the world in aviation. There are 13 countries that have one, and more are growing. The International Civil Aviation Organization, ICAO, has now made it a standard for all member states of the world to have reporting systems. So more and more are coming up. We are running the Federal Rail Administration confidential reporting program for the nation, and this is a growing project with more and more rail carriers joining. Unique aspects. It's system-wide. It's system-wide alerting. It is data processing through experts, and it is the most expensive piece of this process, but it is well worth the dollars to have people who know what they're reading in front of them understand it and capture the real data behind that. It is a taxonomy that's still developed over time, but it covers us. It's about 1,600 potential fields that the analysts can use to capture the data. There are strong immunity and legal provisions. That helps. Sometimes the system gets called the get out of jail free card. I don't care for that characterization, but this immunity is an incentive. It is not the reason why people report. If I look at my reports today, it's about 42% that I could ever say is even linked to an enforcement regulation of any kind. Now, this is a mature system. People have learned how to use it, how to put the safety information in, because they begin to see the output and improvements in aviation. Sharing, the collaborative mentions that we've heard are very important here, and aviation is very robust in that. And this international national reputation helps also build the trust. And I thank you very much for presenting what this system is. It's been built in the United States, and we get a lot of credit credit for out in the world for having something open and allowing people to talk about what really is happening.
Good morning, everyone. I want to thank everyone for the opportunity to be here. Very honored to be here and to have the opportunity to folks to believe in the fire service and the public safety community, the efforts we are working on with regards to near miss and lessons learned and how that applies across so many different disciplines. This system was started in 2005. It is a legacy system by short standards with regards to what Linda has been working on, but a lot of our success is directly related to the involvement that Linda's had when we tried to stand up the program in 2005. As a legacy system, we headed down a pathway. However, when you start operating within public safety and you look at the individual silos, what you find is we're maybe not leveraging the information that has significant value, and we're missing the real issue at hand. So, for example, if you look at an accident that occurs on the interstate, and then you look at the different stakeholders, because we've talked about the importance of collaboration and stakeholders this morning, how do those play an important role in creating those outcomes and that data? And the players that are involved is everything from the fire service to the EMS service for pre-hospital care, law enforcement community, towing and recovery industry, highway workers, Department of Transportation. All these folks are very prevalent and are present on just a single event that occurs on the side of the interstate. And in the event that you sit in that environment, each one has a different perspective in the event that a near miss or close call happens or potential struck by. So as we tried to reset the program over the course of the last year and prepare for our new launch that happened about 60 days ago, we really transitioned from the firefighter near miss to what is now our more of a national near miss program for public safety, and even started creating some new URLs, which is listed up on the board as www.nationalnearmiss.org. So that's kind of the things that we have gone through as we've done this. In the transition from the history and the legacy program to where we are now, we not only wanted to address lessons learned that were extremely relevant and important, but we wanted to now transition lessons learned into lessons applied. Keeping the foundation of the program, as Linda's already talked about, being anonymous, being voluntary, and being non-punitive. But the thing that just kept coming to the surface is, number one, what questions do you ask? Do you ask a lot of questions to gather data, or do you ask a few? What's your stakeholders or your discipline's involvement? How do they want to understand the questions that you do ask? And I will tell you today, we still challenge ourselves as far as where is the bar need to be set on the reporting side. So we've created a project that's been very agile. And part of the agile process is so that we can get that constant feedback and improve upon the way we do business and improve upon the system and the capturing it. The second thing that I think we ran into was, as you start collecting data, how do you then go out and mine that data and information so you can identify, as Linda said, the pearls or the nuggets of wisdom within the data in order that things will quickly surface so that you can create reactions and make successes out of it at the end of the day. So those are some of the key things that we were really challenged with as we relaunched the program and had it move from where it was before to where it is today. We have also maintained the 2 review process through our subject matter experts, which we have felt is extremely important in order that reports have the ability to be de-identified, and then they have the opportunity to be reviewed by those 2 different subject matter experts before it gets pushed on into a venue such as the website and the database that folks can learn from it. I had the opportunity to visit with several folks from the Department of Defense side here recently, and one of the individuals at the table said, you know, the part of lessons learned, if you don't transition them into that lessons applied, can just be a mistake because no one ever had the opportunity to leverage what was there. So as we moved into the lessons applied side of things, we really wanted to start addressing the behavioral change. Because when you start looking at the behavior change in the emergency and the public safety community, we operate in that crisis environment. And what makes a good leader? What makes a good officer? What makes a good fireground commander? And what we found is what makes a good decision maker in that crisis environment is the same whether it's in the military side or whether it's in different parts of the decision-making process. And that's what led us to really that recognition prime decision-making. And the purpose of that is to really be able to, through training, constantly have our folks exposed to the information so it becomes second nature to them. So we've done a lot of work in trying to assure that that was very relevant as we looked at the lessons applied part of that. The things that we've done with the system to make that relevant is we've done some of the historical pieces of the legacy system, which was called a report of the week, where every week we send out a piece of information that's relevant to a significant near-miss event. And these are the types of information that folks can print off. They can socialize around the kitchen table at a firehouse or at a law enforcement briefing. They can print it out at shift change and chat about it. But what we also heard is budgets are tight. Resources are not there. We need some things that will provide us great value with an easy lift. And to do that, we started creating other opportunities. We created components that is called a training bundle that now allows instructors and leaders and folks in different environments to take the results of the near-miss program, apply those results into whether it's a 10-minute training program, a 30-minute training program, or we're going to actually put it in a leadership curriculum that's going to be taught at the National Fire Academy or at an individual company level officer within an individual department. So those were some of the things that have started to be created out of that. The third component of that is the web-based interactive training. And the purpose of the interactive training is really to immerse the individuals in that prime decision-making process so they can really start seeing. Because the challenge that we have, and it may be very relevant in y'all's community also, is we're having a significant turnover. We're having folks retire. We're having folks change the environments that they are. In the fire service that is used to be driven primarily by fire responses, today about 80% of the calls we run are addressed in the medical response side of it. So we've gotten very good with things such as identifying a STEMI in order that we can call ahead to the hospital, bypass the ER, and get that patient in the cath lab so that from the 911 call to ballooning in the cath lab is 60 to 80 minutes. So we've gotten really good at that part of our equation. But because we've seen a less amount of responses and calls associated with fire incidents, we're losing our history. We're losing our knowledge base through retirements and people coming out of the service. So as new folks come in, they don't have the ability to recognize what does the smoke colors mean, or how does flow paths interact and change the spread of fire within a building, and how does that get translated now to new folks who are taking on those roles and responsibilities. So the training element that we infused into the near-miss program for that decision-making allows us now to really go back and look into the database, gather information in order that when they sit there and do a training or a decision-making evolution, each decision that you make through that training now is a result of information that is in the database. So it helps guide and coach the individual through that. So you learn from other folks' events, which I think is a prime thing that the airline industry has been able to do with their system. We just had not gotten that far down the road. The other piece that we really had not focused on significantly was the analytics. And what does that mean? Because if you cannot show the return on investment of a program, you cannot show a change in culture, and you don't have the ability to make a difference with whether it's policy change, governance change, or change in that culture, then we are probably not successful. So one of the things that we've done is in two aspects. We've now started interfacing geospatial components within the system in order that we can see the aspects of what happens in the East Coast versus the West Coast, North, South, are there commonalities, why certain things occur, and then we've started to highlight those key bullet points that are very important to us as far as identifying how to create that governance or policy change. So as the public safety community matures and evolves, we've captured those things and they're now reflected in how we do business and how we operate. So I wanted to thank everybody for this opportunity and having the ability to share just a little piece of the public safety community with such an esteemed group today. So thank y'all.
Good morning. I would also like to take this opportunity to thank John Holloway and the organizers of the inaugural Quattrone Symposium for the wonderful reception and dinner last night, as well as the opportunity to present at the panel today. Also, I'd like to again, personally thank Dean Fitz for all of his advice and support over the last 6 years. I think he must have a soft spot in his heart for surgeons. And I would also like to give a special shout out to my dear professors, Radovsky and Bibas. Sure as hell, a mistake was made. May as well get out the checkbook now. Where were the police? These, as well as many other more instructive and less sarcastic comments, were recently made at a weekly ritual, the Morbidity and Mortality Conference, known locally as the M&M. M&M conferences go on regularly throughout the nation in medical centers large and small, and in most clinical departments, in my case, surgery. M&M conferences are designed to do exactly what it sounds like. Clinicians gather to discuss cases in which patients sustained either additional illness or death while receiving medical care. The concept of M&M itself is not new. In 1912, the American College of Surgeons advocated a standardized case report system for, quote, scientific, clerical, and medical legal reasons, unquote. Sociologist Charles Bosk, in his seminal work, Forgive and Remember, viewed the M&M conference as an open proclamation of accountability and a means by which surgery house staff, or the younger members of our profession, were socialized to the personal attributes of surgeons. And as previously alluded to in 1999, the publication of To Err is Human by the Institute of Medicine and a follow-up work, Crossing the Quality Chasm, focused the nation's attention on the problem of medical injury, and in particular those injuries due to error. To Err also reinvigorated the concept and relevance of the M&M conference in the context of systems analysis. A number of other regulatory and accrediting bodies have requirements regarding the regular analysis of morbidity and mortality events. In M&M case discussions, it is useful to develop a vocabulary classifying various types of injury. Adverse events are injuries caused by medical management rather than the underlying disease. Medical error can either be the failure of a planned action to be completed as intended, or the use of a wrong plan to achieve an aim. And unexpected outcomes are those observed that differ from the range of reasonably expected outcomes as previously discussed with your patients. Well, despite widespread regulatory mandates for the analysis of morbidity and mortality, there is essentially no specific guidance. As a result, the goals and processes by which M&M conferences are conducted vary widely. One framework for a mature error reduction program relies on the cooperative participation of healthcare providers and administrators. Some participants, like myself and Dr. Fleischer, may be both. M&M is generally regarded as mainly on the provider side, with event identification and event assessment as being the most important goals. Event identification is the capacity of healthcare providers to identify events in error-prone situations, and event assessment is generally the particularized study of facts associated with individual patient events. Other methods do exist for measuring and analyzing risk. You've heard of some this morning. In addition, there are the so-called root cause analyses, or RCAs, and the failure modes and effects analysis, or the FMEAs. But these tend to be organized on the administrative side. Ultimately, the goal is to prevent injuries by anticipation and control. As suggested by the two-way arrows, at each level there is the intent to share data and insight across the organization. The primary goal of the Surgery M&M Conference is the identification and assessment of individual cases and thoughtful critique by the attendees. There are additional goals. One is the incorporation of departmental and divisional level data on a variety of patient safety and quality improvement indicators, many of which are publicly reported, and Dr. Fleischer showed you a graph of the Hospital Compare website by CMS, as well as a page from our very own Quality Data Mart dashboard. If relevant, the findings of root cause analyses and the FMEAs are also presented at M&M for what they can teach about better patient care. And although the review of M&M cases is widely regarded as the most educational part, house staff also present additional interesting surgical procedures and the relevant literature review. Such cases do not require morbidity or mortality to have occurred. And lastly, our M&M serves as a continuing medical education function for the participating faculty. Just as you have CLE, we have CME. The conference is traditionally run by the department chairperson or a senior faculty member who selects cases from a weekly list for presentation. Time does not permit analysis of all the identified cases. The residency director is present to assure a consistent level of educational value for the trainees, and a physician advisor, that's me, helps in the logistics of case reporting and reminding responsible residents to list the appropriate cases. The audience comprises surgical faculty from all of the departmental disciplines, as well as fellows, residents, medical students, and mid-level providers, such as nurse practitioners or physician's assistants. There is an expectation of attendance by all faculty, residents, and fellows, and attendance is enhanced by the listing of cases for individual faculty who generally prefer to be present for a discussion of their own M&M cases. Faculty discuss their cases in advance with the resident presenters to be sure there is an understanding of the key issues, especially when particularly complex or unique problems arise in the post-operative period. Faculty members from each surgical division are ultimately responsible for seeing that all appropriate cases are listed for their division. But as a practical matter, it is the senior resident rotating through a given division that is tasked with generating the list. The weekly listing comes up, de-identified as to individuals, in an electronic format allowing the M&M leader to pick and choose which cases to discuss. Each case listing includes the responsible faculty member, the presenting resident, who assisted in the operation, the original operation, and the complication. The format for the presentation is modeled after the so-called SBAR framework. After a brief statement of the problem or the complication, the background history, physical exam, and hospital course are reviewed. The assessment includes patient comorbidities or unique patient issues, as well as a physician's judgmental and technical considerations and systems issues which might have contributed to the bad outcome. The custom is for the resident to present, followed by additional comments by the responsible faculty, and then a critique from the remainder of the attendees. It is here, using a sports metaphor, that the discussion becomes a full contact sport, and when the statements with which I open my presentation generally are uttered. Leadership helps prevent the tone of the discussion from being too acrimonious, and although the presentation of each case is backward-looking, the real intent is to help all participants prevent or mitigate similar events in the future. Although the goals are desirable and the process sound, M&M conferences are not perfect. There are a number of barriers to make it a better system. First, time constraints limit full consideration of each case. Here is a format snapshot of cases that were listed for the Penn Surgery M&M. There are three entities: the Hospital of University of Pennsylvania, Pennsylvania Hospital, and Penn Presbyterian Medical Center, and there are 7 divisions: colorectal, gastrointestinal, endocrine oncologic, thoracic, transplant, trauma, and vascular surgery. There were 407 cases listed, as broken out in the attached slide, or about 100 a month. This translates into 25 per week, for which there is approximately a 90-minute meeting to get through. Further, physicians, being human beings, do have a hard time admitting less than perfect outcomes to themselves, much less to their colleagues or patients. Susceptibility to this myth of infallibility can lead to negligent, knowing, or even intentional underreporting, but even more mundane problems such as intentional underreporting. In certain spectacular cases, the grapevine will often help identify such cases, but for mundane problems such as infection or medication error, these can be harder to ferret out. Conversely, the contemporary approach attributing many system adverse events to system errors, there is still a tendency in the M&M conference for the blame and shame approach, which we work very hard to eliminate. There are no good information technology solutions to identify all the errors, but sometimes we can identify laboratory data like microbiology or unplanned hospital readmissions to be a surrogate for cases which should be reported. And often the assessment portion expends a great deal of time on the anecdotal experiences of surgeons rather than driven by hard data. And in point of fact, in many circumstances, there is not good evidence-based data on which to base your discussion. In summary, I would just like to leave you with several takeaway points. These amount to bald assertions, as time does not really permit an analysis of the data, if data even exists. 1, outcome conferences such as the M&M are intended to improve the future by learning from the past. 2, error assessment requires a working vocabulary, and that will be somewhat similar in the law as it is in medicine, but there will obviously be differences, as previously discussed. 3, systematic review of the complications is also educational, not only for trainees, but for the practitioners involved. And lastly, there will always be barriers that exist, and these require constant attention to maintain conference integrity. Thank you very much.
Good afternoon. I want some energy in the room, please. Good afternoon, everybody. All right, okay, so you got me on the time, but we're getting close, though. We are 10 to 12, rather. So I'm going to discuss the role of the media in setting the stage for wrongful convictions, and conversely, I'm also going to discuss role of the media in assisting in exonerations. It's important to understand when one starts out that often what happens outside of the courtroom can be just as important at times as what happens inside the courtroom. An example of that was an exoneration in New Jersey where Byron Halsey was wrongfully convicted of a child murder and wound up serving 19 years in prison prior to being exonerated through DNA evidence. The atmosphere in which his case was tried, caused in part, though not solely, by the media, was that when he narrowly avoided being sentenced to death as a result of one juror holding out, the crowd in the courtroom jeered. How is it that the media can set the stage for wrongful convictions to happen? Well, here's how it can get started. Firstly, it can be caused by the prosecutor. A great example of that would be the Duke lacrosse case, where rogue prosecutor Mike Nafong made a number of misstatements and other unethical, he broke a lot of rules, and the end result of it was about 300 guilt-oriented presumptive media pieces of one time or another were released, and it set a horrible context under which the case was tried. In the Duke lacrosse case, fortunately, the defendants, their fathers were people of means, so they were able to get quality attorneys. The Attorney General of the state ultimately intervened in the case. In an ordinary scenario, however, most defendants do not have means. They would have been assigned public defenders with very meager resources, and certainly the Attorney General would not have intervened. And so the end result would have very likely have been, based on many other cases, the defendants would have been wrongfully convicted, publicly excoriated, and never heard from again, unless by some miracle they were somehow exonerated. So by the prosecutor is one means by which it can happen. Another aspect of it, most interesting, is it could be started by an advocacy organization and or individual advocates. A great example was a case in Westchester involved an off-duty New York City police, transit police officer, Richard DiGuglielmo, who shot and killed a bat-wielding assailant who had struck his father in the leg with a bat, broke the wrist on the second swing, was in the process of swinging for the fences his father's head at the time in which the police officer shot and killed the assailant. Witnesses got on national television and declared it to be a clear case of self-defense. But the officer happened to be white, and the person who was killed happened to be black. And as a result of that, there was a knee-jerk reaction that this is just yet another instance of police officers committing an unjustifiable shooting. And so protests were organized based on the color of the players involved. The end result was that the officer was convicted. Another way it can happen is it could be sua sponte, all the way down to the level of the reporter or the columnist. If something strikes that media person as being a particularly heinous or outrageous or egregious crime, that can be the motivation under which guilt-oriented presumptive articles initially appear, and then it becomes kind of a snowball effect where other members of the media piggyback or are influenced by that original work. What are the solutions? Well, firstly, fair reporting. I think it's important that an awareness raising be made in terms of the media that the police officers and prosecution, when they make statements about a case, it's not always accurate. I hearken back to my own case where police officers made statements about this confession that they obtained in my case, conveniently leaving out that there was a threat and a false promise which was made in order to induce that coerced false confession. There's a thinking amongst some people in the media that defense attorneys will say anything in order to get their clients off, even within the court of public opinion. But it's important that it be acknowledged that sometimes, believe it or not, I expect this will probably generate a laugh, defense attorneys actually are telling the truth, right? Who would have thought? Sometimes defendants are actually innocent. So it's important that that concept in their head, that predisposition to discount whatever the defense attorney is saying, be combated. Fact-checking is very important. That kind of ties in with defense attorneys making statements. Do they have the evidence to support the statements that they're making about their case? It's important that reporters read the legal motions. Often defense attorneys will not speak about the case, but that doesn't mean that the perspective of the defense can't be ferreted out by reporters and reported on. Reading legal motions, paying attention to cross-examination, focusing in on closing statements, these are all indirect methods by which reporters can learn what the defense position is and thus report a case even-handed. Another solution is that we need more defense attorneys to think outside of the box. The conventional thinking is not to make any statements, I'll try my case in court. But meanwhile, there's prejudicial publicity going on in the case. The other side is making statements about the case. I think that responding to these verbal attacks is very important. I think that not only should the defense attorney make statements, but they should carefully work with their client and carefully craft some statements that could be released on the part of the defendant. Otherwise, all these statements are going to be made from one side, and that very easily can translate into guilt-oriented presumptive reporting. How is it that the media can assist in exonerations? A number of different ways. First, I'll go over some direct methods. Investigative journalism. Investigative journalist Peter Shellum, now deceased, received an award a few years ago at the Innocence Network conference in which he assisted through his investigative journalism. 5 exonerations were obtained. So investigative journalism is one manner by which the media can help to achieve exonerations. Then, what I'll call building a movement. Producer Joe Berlinger, who produced the documentary Paradise Lost, who wound up creating 2 additional versions of that, Part 2 and Part 3. That really put the West Memphis 3 case on the map. As a result of that, a lot of public attention came to the case, a lot of celebrities came to the case. The next method will be what I call media around a case once it's ready to go to court. Let me give an example. In New York, in a non-DNA case, reporters had been covering the Marty Tankleff case for a number of years. It got to the point where, even though Mr. Tankleff hadn't been exonerated, reporters were tired of reporting about his case. Yet, a substantial amount of evidence in the case had been gathered. It was in front of the court. He had lost the post-conviction motion, and now an appeal had been filed at the appellate division. Mr. Tankleff had the luxury of having a public relations firm, Sori Communications, working with his team. At the time, I was still hot in the media. The media was reporting almost everything I did. And so Mr. Sori said, he reached out to me and he said, we're going to put a press release out around Marty's appeal, and we would like to add your name to the press release because we're having some difficulty in getting media attention. But we think that setting the stage outside the courtroom would be important so the judges know that the public is watching this case. And of course, the obvious end result that was wanted was getting a fair appellate consideration. Appellate courts are very poor at this present time at catching and correcting wrongful convictions. That's why the average length of wrongful incarceration is 13 and a half years, and that's why in majority of exoneration cases, appeals have long since been exhausted at the time at which the exoneration is obtained. So that was the reason why it was important to have that setting around the case. So the press release went out, my name was utilized, and media showed up. And as soon as we stepped outside the courtroom, a lot of microphones were thrust in my face. And Jeffrey, why are you here? What's the similarity between the cases? And the end result was a really good appellate division decision reversing the conviction. What are ways in which the media can assist through indirect methods? There's what I refer to as exposing rogues. For those that are familiar in the field, names like Fred Zane and Pam Fish, who engaged in forensic misconduct, in which dry labbing, which is a sarcastic term in which there's no water needed. We're not putting slides under microscopes. It's all I'm going to just write reports and just skip that step. Stephen Hain, Dr. West, Preston with his dog scent testimony, junk science. When the media reports bad actors within the system, that can assist in exonerations because now defendants, defense attorneys, and their advocates will be aware of those bad actors, and now that might provide a new line of attack for wrongful conviction that was previously unavailable. Connections. That's another manner by which the media can assist in achieving exonerations, assist the process. What do I mean by that? For most people who are wrongfully convicted, alarmingly in some quarters, it's not lawyers or other members of the criminal justice system, police, prosecutors that are proactively looking for wrongful convictions, and that's how they came to look at a case. Instead, it's often an advocate. There's usually a bridge between the wrongfully convicted and that necessary legal help. How do people become aware of a wrongful conviction case to then look into it a little bit further and possibly become that advocate and build that bridge between the person who's been wrongfully convicted and the necessary legal services? Well, one method by which is reporting on that individual case. How do we do it? Firstly, my advice is avoid cold approaches. What I mean by that is if you're an attorney or an innocence organization working in this space, I think it's important to position oneself with local media, both on a county level, on a state level, and even nationally, when they're working on stories that pertains to wrongful convictions that don't necessarily involve your particular case. I think it's important to reach out and to be willing to share information so that once your case is ready to go to court, the columnist or reporter has some familiarity with you already. Another thing is unconventional partners, both direct and indirect. I remember some years ago, the Columbus Dispatch, they worked with an innocence organization and they profiled a number of cases which were questionable and in which DNA testing was sought, and they had been unable to obtain it. So as a result of the reporting, the district attorney eventually wound up allowing some DNA testing to happen. Another example of unconventional partnership, this time in a more indirect manner. We all understand that raising public awareness about the systemic deficiencies that lead to wrongful convictions benefits in an uncountable number of ways. Looking for an unconventional partner, one example would be, there's a radio show which is called I've Been Falsely Accused, which appears every month and a half on the Conversations with Koji channel on 1230 KLAV, which is available to be listened to online. Having general wrongful conviction information disseminated out there can help to educate the general public on the issue of wrongful convictions, and that's who makes up the jury pool. That's who the judges and other attorneys with the prosecution or defense that are handling the cases, their awareness of wrongful convictions is very important. The ways in which an individual cases can be impacted, and then my last point, then I'll wrap up. Firstly, in terms of the jury, it's naive to, the jury pool can be impacted. It's naive to believe that jurors don't read about cases either before the jury pool, when they're selected as jurors, or even in the deliberation room. So that's how it can affect the jury. It can have an impact on a judge. If a case is a high-profile case where articles are being written guilt-oriented presumptive, do you really think that when the judge has to decide a suppression motion, whether or not a confession is going to be suppressed as being involuntary, or whether an identification is going to be excluded because it was unduly suggestive, the judge, knowing that there's prejudicial pretrial publicity, that there's a firestorm of momentum as against the defendant, that it never enters into any judge's mind ever in any case? Of course it does. Does it not play a factor in whether or not a judge decides to exercise his or her discretion to set aside a conviction as being against the weight of the evidence? Though seldom exercised, it is something that a trial judge has the possibility to do. I submit that it's less likely in cases in which there's prejudicial pretrial publicity. It certainly can impact the sentence that a defendant draws. With that, thank you very much.
Thank you all panelists. If I could just, if we have time for a couple of questions if people want to go to the mics, if I could just draw together what I see as a couple of interesting threads, but also tensions in the remarks. One of them is this tension between focusing on individual cases, which is the way that we come at the problem, versus getting together bigger patterns. And I think that, that's the way the media tend to come at it, though there are investigative journalists like Maurice Posley who do more connections, and that's the way morbidity and mortality conferences start, and that's the way that individual, airplane accident reports start. But also the tension between the kind of the blame and the individual misconduct of attribution, which is sometimes appropriate, and the, let's focus on fixing things approach, which gets to the final tension between, are we doing this in terms of ex post, looking back at this individual case, and to what extent are we turning that into something ex ante that's going to fix future cases, whether it be through training or protocols, et cetera, and the role of culture and systems in doing all that. I think it's very valuable to see these connections among some very different seeming fields. We have time for about 2 questions before lunch.
Okay, my name is Marvin Zellman. I'm a teacher and educator at Wayne State University, which someone asked me where it was today. It's in Detroit. Mm-hmm. I'd like to step back a bit. Because I'm an educator, I don't work on exoneration cases. I don't actually develop new models, but I try to understand the system, write about it, and then teach students about it. And I was curious listening to Linda Connell, but anyone else could chime in. I was fascinated. I've heard about this, but I knew very little about the details of your amazing program. When you indicated there were lots of regulations out there, I said, oh, that could be in a law school class. And I was wondering, is there stepping back into, perhaps a graduate level education in aviation, is this information provided, say, in aviation law classes and business schools? Do you have case studies, engineering programs? How does this information get translated back to students who maybe at an undergraduate level is probably too far to learn about it, but do first-year med school students learn about M&Ms, what they are generally and the like? Could you comment about educating future professionals?
Yes, I'm the government. I'm here to help you. All this information that the ASRS collects is public. Once we've removed the identity of the person, so personally identifying information is gone. Third-party references that might lead back to the discovery of who that person was is gone. This is sanitized data. Once that job has been done by us through our experts and decisions about that, it is public data. So we put this data that we're able to fully analyze online. So you go to our website and you have access to it. So for instance, at the university, I'll just take one example, there's aviation universities. North Dakota's one, Embry-Riddle. Their students and professors use this data to take hypothesis generation and follow through with more typical kind of research paradigms. Using this data as examples of the kinds of real-life events and outcomes that were evidenced there, and then use other data sources through, the typical research approach of literature research and other data sources to bring it all together. Now, how much of that gets put into other programs and training, et cetera, I am not aware.
All right. I think you were next.
Yeah, actually, just a quick technical question.
What's your name?
My name is James Anderson. I'm from RAND.
Right.
It's really the liability protections associated with the M&M conference. How does that work? And are there efforts to breach them for discovery or the like?
Well, as I learned in my evidence course, if there is a physician privilege, it's a very leaky privilege. The way that it generally gets protected is under what's called, it's considered a medical quality assurance activity, and as a result, most states have some form of protection for that kind of activity. Secondly, it is, as I mentioned, de-identified, so although if you knew something about the individual service or you knew something more about the individuals involved, the information that's presented in the conference is fairly de-identified, and in fact, from time to time, even the resident presenters have some difficulty remembering exactly which urinary tract infection or which wound dehiscence they were or bowel obstruction they were talking about. So, and third, almost none of this is written down. Now, in distinction to Dr. Leap's admonition and to the tremendous amount of data that is generated at various levels, as I showed in my framework, the M&M conference tends to be a much less documented process. So there's not a lot of information that could be discovered other than hearsay, something people heard. And secondly, and as I said, for the most part, it is protected.
Thanks very much. Okay, we have time for one last question.
I'll try to make it short. I'm Steve Handelman, the Director of the Center on Media, Crime, and Justice at John Jay. You actually foreshadowed my question a little bit. Jeffrey spoke very eloquently about the role of the media in individual cases, and the media does go after bad apples. We know that investigations do look at systems, but for the most part, the media needs bad cases, extraordinary cases to make stories. They need names. And Ms. O'Connell mentioned the fact that a lot of the names you get in your system are stripped of their names. So you have to be confidential. So my question is really, how much of a closed loop do you need your reporting system and analytical systems to be in order to be successful? Does the media have a role in that? I mean, do you see a sense where the media can actually contribute to that instant feedback that you need and that long-range feedback that you need when you're looking at critical lapses in the system?
I deal with the media. A good part of my job is dealing with the media requests because this is public information. So I often try to join them in their quest to report responsibly. I make that assumption at the outset. And I usually preface this with, this is, aviation's complicated, and if you're not an aviator, you could look really stupid if you don't write this correctly. Now, I'm the government, I can't censor what you're doing, I encourage you to report, I'm all for that. But I would suggest, if you're comfortable, to send me what you're writing. I'd be happy to comment on it so that you can look authentic. Therefore, I've been able to work with the media to really get out to help them come around from sensationalistic attempts. And when you're not from inside aviation, some of this really looks bizarre and scary. So I work with them and I educate them about what the real issues are and what the perspective is around those issues. And they've actually come out with some very good articles that I think advance the dialogue around these safety issues. But again, I have to solicit them basically to work with me on this so that the real message gets out.
If I could just add one cautionary comment on that. One thing I've learned in researching media and criminal justice is I think there's much more deference given to the idea that there are experts in medicine or experts in aviation than to the idea that there is expertise in criminal justice. And one of the deep problems we have in criminal justice is people will not defer to a sentencing commission. They will not defer to, you're working uphill against the sense that I've got a gut sense of what that guy did and what he deserved. And if you want to talk about risk reduction or recidivism or anything else, you have much more work to convince the media that they're going to look silly because everyone thinks he's an expert in criminal justice. And I think it's a bigger problem in our field than in yours. Not that we can't learn from it, but we've got more headwind that we're going into there. So join me in thanking our panelists for a wonderful discussion.